Good afternoon, everyone. I'm attorney Ahmad Yakzan from the American Dream Law Office, here doing our um, weekly stream, answering your immigration questions. If you have any questions, we're on TikTok, LinkedIn, Instagram, YouTube, and Facebook today. If you have any questions, please drop them. If you um, have a specific question about your own case, please don't um, mention a lot of sensitive information in the chat. You can always email it to us at intake@americandreamlawoffice.com, or you can actually drop a direct message to me, and I'll be more than happy. I'll be more than happy to answer it in the direct messages, and we'll get in touch with you. So our goal today for TikTok and YouTube is to reach 1,000 followers. If you guys can keep the hearts going on TikTok, I would really appreciate it. And if you can follow us on YouTube, LinkedIn, and Facebook, I would really appreciate it. The handles for all of our social media is at American Dream Law Office. So if you want to go to Instagram, YouTube, LinkedIn, and Facebook, our handles at American Dream Law Office. I would really appreciate the follows, guys, especially on TikTok. I'm trying to reach 10,000 followers, and we're maybe 500 off. So if you guys want to follow us, I would really appreciate it. Again, follow us on TikTok, Instagram, YouTube, and Facebook. Again, all of our handles at American Dream Law Office. I would really appreciate it. So I do have a bunch of questions that we got from our followers over the week. I do want to ask you guys on TikTok and the other streaming services, if you could actually share the live. I would really appreciate it. So the first thing I want to talk about today is, as I expected, and if you were watching us last week, as I expected, there was a lawsuit filed by Republican attorney generals. About 14 of them filed a lawsuit to enjoin the administration from doing the parole in place program that President Biden announced in June. So if you are planning to apply, I would apply as soon as possible. So if you're trying to apply and you qualify, please do it as soon as possible. Now, the type of stay that happened on Wednesday, I believe yesterday, was just an administrative stay for 14 days. And what that means is that the court, by its own rules, sometimes actually puts a stay on something getting done if there is a lawsuit. So it's an administrative stay from the court. It's not on the merits, which is actually a very good thing. And because it's an administrative stay, that means that the government can still accept applications on this. There is no injunction yet or a nationwide injunction on the parole in place program. So if you want to apply, I would do it as soon as possible. Again, you can call us. That our turnaround time is very quick on them. Give us a call. Again, the number is 888-963-7326. Or if you want to join us on WhatsApp, call us on WhatsApp. The number is +1 727 3019 328. The one thing that you have to understand, because we got this question this week from someone who called us, is we got a question: can I apply for parole in place while I'm overseas? And that is just not possible, guys. I mean, you have to have been in the United States for 10 years for you to be able to apply for the parole in place under this program. There is other parole programs that you're allowed to apply for Venezuelans and Cubans and Haitian, for example. You can apply for those if you're outside the country. But if you're here in the United States, the only parole that you can do is parole in place, or another parole program. For example, some laws like the Cuban Adjustment Act allows for parole here in the United States. But unless there is an actual place, if there is an actual program to allow you to get to allow you to actually get a parole in while you're here in the United States. There is a program that has to apply for you to be able to do it. We got a question: can DACA recipients own guns? Please don't. I mean, you're under a program. It's an administrative program that the government is allowing you to stay here in the country. Please don't own a gun. I don't own a gun until you become a permanent resident. So please don't own a gun if you're on DACA. You're going to be in trouble. Don't do that. For whoever just flagged us, thank you so much for doing that, and thank you so much for being such a nice person. I haven't spoken anything personally or anything like that, but I appreciate it. Thank you so much. So the other questions that I've gotten this week, I have them on my phone, and I'll be more than happy to answer them. I'm looking at the questions. Someone says that they filed that they're married to a lawful permanent resident, and can they apply for a green card? If you're married to a lawful permanent resident, you have to be in status in the United States for you to be able to get the green card. So if you're out of status, you are not allowed to actually get permanent residence under getting married to a green card holder. So what we usually do is try to naturalize the green card holder before you can apply for the I-485. So if you made a legal entry into the United States and you're married to a lawful permanent resident, you're gonna have to be you're gonna have to be in status for you to be able to adjust your status in the U.S. Someone asked if they're going to continue processing PIP after September 6th. It's going to depend on whether there is an injunction or not. So what usually happens is when you file a lawsuit against the program, now the states are asking that they're going to be injured by the program and all of that stuff. So for an injunction to be entered, not an administrative stay, for an injunction to be entered, the plaintiffs have to prove that they're going to be injured by the program not being stopped. So as I said earlier, if the court actually enters an injunction, then the government will not be able to even accept those applications. So for example, right now, if you're on DACA and you applied for it in 2012, you're okay, but you cannot apply for DACA for a new applicant because there is an injunction from the same court saying that the government cannot actually take DACA applications. So it depends on what the court does after September 6th. That's when the administrative stay ends. And if the court doesn't enter an injunction against the program, they should be okay. If they do enter an injunction, then we're going to be in trouble. That's why I'm saying apply right now, because they're actually doing the program right now. They're still accepting the applications. They can't work on them. They can't grant them, but they can still accept them. So apply as soon as possible. Okay. Again, please don't put personal information on here. That's why I got flagged, guys. Please don't put any personal information. If you want to talk to me about your case, I would really appreciate if you can call me. My phone number is 888-963-7326. And if you want to join us on WhatsApp, call us on WhatsApp. The number is +1 727 301 9328. I do not want to answer personal questions about your case on a public forum like this. It's not going to look good, and I don't want other people to listen to your personal business. So please don't leave any personal things here on TikTok or in a public forum like this. Thank you. Okay, so the questions that I have, the first question is, I'm a U.S. citizen planning to get married to a non-citizen. Is it better to get married here in the U.S. or in the country where she's from? Now, the question is a little convoluted, and I'm going to kind of explain a couple of things. Now, I always tell people, is it better to do things here in the United States or overseas? Absolutely, here in the United States trumps doing things overseas 100%. Now, if the person is here in the United States and made a legal entry and they're getting married to a U.S. citizen, there is and if there is no problems with if there is no problem with inadmissibility or deportability or anything, there is no criminal record or anything like that, you always apply here in the United States. Apply here in the United States 100%. And I say it for a couple of reasons. Number one is, it's very hard to appeal a decision when it's done overseas. There's something called the doctrine of consular non-reviewability, meaning that if you're overseas, it's very hard to sue the government on an erroneous decision that they made if it was made by a consular officer. Meaning that if someone at the consulate denies your green card, I'm having this case right now, the exact same case, denies your green card, you cannot sue the government to actually get the green card. That's going to be a problem. Okay, that's number one. Number two, if you're here in the United States, I'm going to be able to defend you and apply for waivers and all of that stuff. While you're here in the United States, you're going to be able to probably get your work permit. You're going to be able to do all of these things while you're here in the United States. And once they deny you everything, then if they deny you everything, you can actually go and sue or be in removal proceedings and apply for your green card in front of the immigration judge. So always do things here in the United States if you can. The second reason why I say that is, it takes substantially longer to do cases overseas. So if you're applying for a permanent residence, for example, through consular processing, it's going to take 2 to 2.5 years, and the person will have to be overseas, and they're not going to be able to come to the United States, with exceptions. They're not going to be able to come to the United States and all of that stuff. So if they're here in the United States, you go ahead and apply for adjustment of status, and that's taken between a year to a year and a half. It's not going to take longer than that. So you know that in the United States, it's gonna be faster, it's gonna be better, and you're gonna be together. That's why I would say apply here in the United States instead of applying overseas. Now, the last part of the question is it better to get married overseas or get married here in the United States? Now, it doesn't matter. As for a marriage, it's a marriage anywhere in the world. It doesn't matter. So if you get married in the person's country or you get married here in the United States, it's the same marriage. As long as the marriage is actually legal in the country where it happens, then it's fine for the United States. Now, except when it comes to polygamous marriages. So I know countries allow polygamous marriages, and the United States doesn't allow polygamous marriages. So if you're married to more than one person at a time, you're not going to be able to get a green card using that marriage. So that's the answer for that question. Okay, the next question. I have a criminal record. Am I eligible to apply for the parole in place? The guidance that you have is, it doesn't matter. You're gonna have to prove you can apply for parole in place. The problem is going to be, are you gonna be able to prove that you deserve the parole in place or not? Because it's a discretionary thing that the government is giving you. So if you have something that's going to end up putting you in removal proceedings, I wouldn't apply for parole in place, because I've seen people actually get placed in removal proceedings before because they applied for something they're not supposed to do. They're not supposed to apply for. I had a client once who stayed outside the country for more than 11 years. And when he came back to the United States, he applied to renew his green card. And when he applied to renew his green card, he was placed in removal proceedings. And I had to go defend him in removal proceedings. So always consult with an attorney before you do something. If you have a criminal record, especially something that has to do with drugs, something that has to do with moral turpitude, like a felony theft or anything like that, I wouldn't apply for parole in place and talk to someone like me. Again, you can call me and schedule an appointment with me. You can call me and I'll be more than happy to discuss it and see if you should apply for it or not. Now, I'm representing some people who have criminal records and were applying for their parole in place because the cases were dismissed or it wasn't something that's an inadmissible thing. So we actually ended up applying for their parole in place. But if you're not if you're not sure, or if you have something really serious on your on your background, I wouldn't apply for parole in place, at least without speaking to an attorney first. Again, guys, please don't mention anything personal about your case. If you could, please send me a DM or send me an email at intake@americandreamlawoffice.com, or go to my website. You can go to my website, www.americandreamlawoffice.com, and submit a form for us to call you and schedule an appointment with you. Please do not leave personal information on this. We already got flagged today once because of it. Please don't leave anything on here that has to do with your case. And I'm doing that to protect you, not because I don't want to answer your question. I would like to protect you. Please don't do that. What other options do I have on getting a denial for student visa? Oh, that's one of my favorite questions, because I don't know if you guys know, I came here to the United States on a student visa myself. I was on it for a while, then got my H-1B, then got my green card and my citizenship. So my F1 status, I'm an expert on F1 status because I was on it for so long. Now, an F1 status is for someone who's a student who wants to come here to the United States and attend school, either language school or go to community college or university. And it goes all the way to PhDs and postdoctoral work and all of that stuff. You can be on an F1 visa. Now, the question says that they got denied for an F1 visa. Now, if you're denied for an F1 visa, the F1 visa is a non-immigrant visa, meaning that for you to actually get the visa means you have to prove that you are not, you don't have immigrant intent, meaning that you're not coming to the United States to stay for good. You have to prove certain links to your country. You have to prove that you're going back to your country for you to be able to actually get the F1 student visa. The second trap in the F1 student visa is, are you going to be able to financially support yourself? So I've seen people, for example, get admitted into a school, and they're going to a university, and they have $20,000 in the bank, and the tuition is $50,000 a year. So the consular officer is going to think, okay, you're going to go to the United States and actually work for you to get to pay for college. That's why they're not going to give you the student visa. Now, if you're denied a non-immigrant visa, there is always a wait 30 days and then apply for your student visa. Now, if the denial was here in the United States, you can actually appeal it. Unfortunately, if it's at the consulate, you actually have to reapply. But you're more than welcome to reapply for any non-immigrant visa. It doesn't have to be just a student visa. You can actually apply for a non-immigrant visa again. Just wait about 30 days before you do it, and try to fix the things that the consular officer denied you for. Guys, we're on TikTok. We're at 1.6K likes. I would really love it if we actually reach 2,000. No pressure, but I would really appreciate it. Thank you so much. And also, if you're seeing us on TikTok, please follow us. I would really appreciate it. I'm almost hitting 10,000 followers on TikTok, and I would really appreciate it if we can do that today. I'm only about 400 people away. Thank you so much. All right. I got the same question. After a denial of a visitor visa, what other options do I have? It really depends on why you were actually denied. As I discussed earlier, that it's a visitor visa is also a non-immigrant visa, just like the student visa. So if you were denied because you don't have enough connections to your country, then you're gonna have to fix that before you can reapply. But you can always reapply for a visitor visa, just like you can apply for a student visa. Now, if you're applying for a student visa, for a visitor visa, and you're from a country with a higher recidivism rate, it's going to be a problem. So that means that a lot of people from your country come to the United States and don't leave on visitor visas. One of the options that I absolutely love is that if you're a businessman overseas and you're trying to come to the United States, don't apply for a visitor visa. What you're going to want to apply for an investment visa. That is a much better option for you to actually be able to come to the United States. So if you're in the Middle East, for example, if you're from Egypt, Bahrain, Oman, or Jordan, Morocco, from one of those countries, and you have the means to open a business here in the United States, that's what I would do. I wouldn't apply for a visitor visa if I don't have one. And we can actually get the investment visa while you're in your country. You don't have to come to the United States to do it. And we have the resources to do everything for you. And if you have a friend here in the United States who can help you with finding the business and all of that stuff, that would be great. So we're able to actually do the business and then all of that stuff and open the business and get you the investment visa. That's what I would do if I were you. I got a question. What do you think the percentage PIP will continue? I really don't know. I would love it if it actually continues. There's a couple of problems I have with the lawsuit. The problem with the lawsuit is that the states are saying that they're going to be injured by President Biden using his discretionary powers under the Immigration Naturalization Act to actually give green cards for people. I don't know how that's an injury. If you're actually helping people legalize, that's more money going into your coffers if you're from these states, and these people will be legalized. They will be able to get driver's licenses. They will be able to do a lot of things that are actually going to be beneficial to you. So I don't know what the injury is. I read the lawsuit. I have no idea what the states are saying. That's number one. Number two, going back, Obama got sued over DACA, and it went all the way to the Supreme Court, and the Supreme Court decided that they're actually going to allow it. So I don't know what the difference is. It's already, the Supreme Court has already ruled that it's in the president's power to do these discretionary programs. So I truly have no idea. On the other hand, it's the issue is they sued in the Fifth Circuit, and the Fifth Circuit is known to be very conservative, especially when it comes to immigration. So they sued in the Fifth Circuit on purpose because they are actually they're the most overturned circuit in the country, because a lot of the conservatives actually go to Texas to file these lawsuits, and some of them are actually bogus. I'm not saying that this one is bogus, but I don't know what the merits of this lawsuit is. And I'm hoping the Fifth Circuit will actually see that this is politically motivated and it's within his power to do it. As I said, there are at least 2 programs right now that the president is using to allow people to stay in the country. There's a parole program that we're using for Venezuelans and all that. No one has sued on that. And the second one is when we're using parole for spouses and parents and sons and daughters of people in the armed forces. So I don't know why they didn't sue on those programs, but they sued on the one that the President Biden is doing. So I really don't know what these are. I just know I'm 100% sure this is going to end up at the Supreme Court. I'm 100% sure, and that's why I said last week that if you are trying to apply for parole in place, do it as soon as possible. Put your foot in the door. Don't wait, and do it as soon as possible. Do not wait until the program is done, because if you put your name in the basket right now, they can't take it away. Please do that. Also, always remember that there is Someone said they sued for the Venezuelan parole. I know that. I know that. What I was talking about was I was talking about the one for the military spouses. I apologize if I misspoke. But I really think that they're probably not going to win this. I hope they don't actually win this, and this is going to help 500,000 people. So I would absolutely love for the program to. But again, as I said last week, this is going to happen. So do it ASAP, ASAP, ASAP. Do it, please. Okay. Also, don't hire notarios. Hire an attorney to do this. Don't do it on your own. Hire someone to do it. Okay, so we got a couple more minutes left. So if my asylum gets denied, is there any options for me and my family? So there are two things under that question that I have to discuss. Okay, so there are two ways for you to apply for asylum here in the United States. Okay, let's say you came into the United States legally within the 1 year. Within the 1 year, you applied for your asylum application with the USCIS. What happens, that's called an affirmative asylum. So when you apply for asylum affirmatively, that means that the government, the USCIS, the asylum part of USCIS is going to adjudicate your petition for asylum. Now, usually you can put your spouse and your kids under 21 into your own petition. So if they turn 21, they're going to have their own petitions. But you can put all of your spouse and your dependents in the application. And then it used to take about 9 years to get an interview. Now they're moving quicker. I know in Tampa, they're about 6 months behind. So I applied for someone in December, and in June we had the interview already. So if you apply affirmatively, you can apply affirmatively in front of USCIS if you came illegally into the United States, and you can apply for your work permit and all of that stuff within 180 days. When you go to the interview, you're going to have to prove to that person who's interviewing you, the asylum officer, that you qualify for asylum. If you don't, they don't actually deny your application. What they do is refer it to the immigration court that has jurisdiction over you. So, for example, if you apply in Central Florida or in North Florida, you're going to go in front of the immigration judge in Orlando. So if it gets referred to the immigration judge, then you can actually kind of appeal the decision to the immigration judge and try to convince the immigration judge to give you asylum instead of doing it in front of the asylum officer. Now, if you get referred to the immigration judge, that doesn't mean that your case is denied. It just means that they referred it to the immigration judge because there is an issue with your application. That's number one. Even if you get referred to the immigration judge, your work permit, all of that stuff will stay intact. Okay. Now, if you are crossing the border, if you come to the United States by crossing the border, there are a couple of things that you have to worry about. Number one, there is a new rule that was passed in June that says that if you don't actually register with the CBP-1 application, you won't be able to apply for asylum when you come here to the United States. That's number one. So if you're coming here, make sure that you actually register with that CBP-1 application before you actually come to the United States. Okay, they're going to send you a notification saying you can come in and all of that stuff after you submit your registration. There is a lawsuit against that rule, and I don't know where it's going to end up, but it's going to. I don't know where it's going to end up, but there is a lawsuit actually against that rule because I don't think it's constitutional. I don't think it actually comports with our obligations under the Refugee Convention. That's number one. Number two, if you come here by crossing the border, you are not able to apply for and you're placed in removal proceedings, because that's what they do, because you're inadmissible into the United States. If you get placed in removal proceedings, you will not be able to apply for asylum in front of USCIS, like we spoke about earlier in an affirmative way. You have to do it defensively. So that defensive asylum is for you to apply in front of the immigration judge. So when you go, you will apply for your asylum in front of the judge instead of USCIS. That's going to take about 4 years to get done. But again, if you do it correctly, if you apply within the year or all of that stuff, you're actually able to apply for asylum in front of the judge. That's and even if you get denied in front of the immigration judge, I have known people that stayed here all the way to the Supreme Court, because you get to appeal until you see what happens with your asylum case. But those are, that just because you're lost, and I've won cases for asylum and on appeal many times, because the judges have an atrocious record sometimes on granting asylums for people who really deserve it. So if you're applying for asylum and you get referred to the immigration judge, that's not the end. That's not the end of the road. You can always appeal. I'm gonna end on this one. Someone just commented, so you think PIP will prevail? As I said, I really don't know. Right now it's a toss up. I have no idea. I think it's going to prevail, but I don't want to give people false hope. All I'm saying is, if you are able to apply as soon as possible, please apply. Email me at intake@americandreamlawoffice.com, or call me at 1-888-963-7326. And on WhatsApp, our number is +1 727 301 9328. This is all the time I have for today. Thank you guys so much for following me, and thank you so much for the 2.8 likes on TikTok. I will see you guys next week. Take care, everyone.